Whoa, wrong camera. Oh, that wasn't a good view. But let's try that again. I am experimenting with a second camera here. And let's see if I can. I'm going up here. Zoom that out. No, that doesn't really work, does it? We're going to have to maybe move that. No, that doesn't work either. Oh, well, sometimes there we go. It won't stay up. I'm trying to, fancify my operation here with some extra cameras, but I've got to stand for it, so it will work next time. Let's go back to the main camera view and count that as a failed experiment, at least for right now. And it was very blue tinted, wasn't it? I hope you guys are having an awesome night. I do see there are a lot of viewers. I know some of you want libertarian tea. At the end, we will serve up a tiny bit of tea. A tiny bit, but not very much. So if that's what you guys are waiting for, you're gonna have to hang around to the end. Something I do want to explain in the beginning, and then we're gonna go right to the show. And I don't know why I didn't delete certain screenshots and stuff here. There's all this cleaning up you're supposed to do before you start a show that I never do, because this is a professional operation. What we're going to talk about today is the petition for review that was filed by the Libertarian Party of Colorado after they were handily dismissed by the district court in their case against Jenna Griswold. Now, we're not going through all of these pages, because most of these pages are just exhibits of things we already went over in the 2 prior shows I did on this. But there is some new information. Now, I'm as anarchist as they come. Do appreciate comments. Thank you when you do comment. If you send a super chat, unless it's something rude or obnoxious, I will definitely answer. And then other ones I obviously answer if I think they're particularly relevant. All super chats matter. We will get to that. Oh, yeah, let me do my support thing. And then I'm going to give you some background here. You please subscribe. Subscribing helps so much on YouTube. It boosts the algorithm. I cannot even tell you how much that helps. And you can follow me on Twitter. I have an unusual name spelling. You can see it there. I am a Karen, but I am a Karen in camouflage with pink hair. But last but certainly not least, I appreciate your support on Patreon, which is patreon.com/Pink Flame of Liberty, and you do get benefits. You get advanced viewings of my other channels, which is Jurassic Dictionary and Pink Parliamentarian, and you also get book discussions that are not released anywhere but YouTube members only, because I do have that as well, and Patreon. Okay, now let's get into the background. I am as anarchist as they come. So when I hear the government did X, I immediately want to go the government sucks. I'm usually on the side of whoever's against the government. That goes without saying. But I also have spent a long time in this party building up a reputation for fairness and steel manning the opposition. And you can't see it on camera, but just in case you can, I do want to mention just something slightly personal, and we'll move right past it. You'll probably notice this more when I put my glasses on to read things, or if I decide not to, I just hold it up to my face, which I probably won't because it will obscure my voice. I have an undiagnosed, they think it's an autoimmune disorder, they're not sure, but when I'm under supreme levels of stress, I call it dragon eye. But my eyes, blood vessels burst, or they fill with blood. It's just the weirdest thing. This eye right now, if I go like that, you could probably see how inflamed it is. If I'm looking straight at you, you don't see it. But from the side, you do see it. So I have a contact lens in this eye no contact in this eye, and it's making it really difficult for me to see. Obviously, I can't put a contact in an inflamed eye, but this is the amount of stress that I have been under. And also, weirdly enough, for those of you who are as old as I am, you might remember a 1970s, early 80s movie called, I think it was called The Fury, where like these people had what do you call it, when you can move things with your mind, abilities, and they were able to make blood just run out of people's orifices, and then you fly them around and the blood would be flinging everywhere. Classic gore movie if you haven't seen it. I'm pretty sure it's called The Fury. Well, also, when I'm under severe stress, I happen to have a lot of moles. It's just the type of person I am. My moles burst and bleed. It is really weird. Reminds me, Wayne, we got to check my blood pressure, as my doctor said. So they're on steroids to try to fix it. But for then, my vision is really, really screwed up. And you might notice it's this eye. Yeah, everything's backwards. This is the eye of the contact in. Oh, this is it. This is the bloody eye. The one I don't have the contact in. Okay, now that we got that cleared up, and everyone has probably left from the disgusting eye show I just gave you. So if it looks like I'm having trouble reading this, it's not because I'm illiterate, it's because I'm blind. So this is a petition for review pursuant to a certain Colorado statute, which we knew they were going to file, and they did timely file it within the 3-day deadline. However, the election was already over by then. And I had already told you, no matter what my predisposition is against the state, I did not think that the petitioners had a strong case. However, I thought they had a stronger case than the court apparently did, because the court dismissed it in full. I don't know if the state is entitled to attorney's fees, but because it was dismissed in full by the court, not voluntarily by any of the parties, I think the petitioners are going to get dinged. But I don't know. Perhaps there's not an expert in this sort of thing. I'm not an attorney. I'm a paralegal. I have some legal knowledge, not in election law. I'm just like you, not holding myself out to be something I'm not. So anyway, they then immediately filed to the Supreme Court within the 3-day window. So timely filed. That's what we need to start with. So let me pull up my little table here and get this and it looks like, yeah, I'm going to put on my glasses, but it's going to look a little funky because, again, I have to close this eye in order to be able to read properly, or like hold it out to here. And they basically repeat the allegations that they did in the original complaint, okay, about the failure of Jenna Griswold. And I absolutely agree. She's completely negligent. God, these glasses are funky, man. They got some chutzpah. Chutzpah's not the right word. Oh crap! What's the Yiddish word I'm thinking of? It's not chutzpah. It's been a while since I've been in South Florida. What's the crumbly, like, you know, when you got a messy face? I'll think of it. But whatever that Yiddish word is, that's what it has on it. Okay. They're looking a little bit better, but they're looking a little bit grimy there for a minute. So they basically repeat the same allegations. You could go watch, I'm going to try to stick it up there, my prior shows on this. So they repeat the issues about the biosystem and so forth. Crap, that word is driving me crazy. Come on, I know I got Yiddish speakers in my audience. What is it called when you got gunk? When you got gunk on your face or you got gunk on your clothes. Really, really driving me crazy. Anyway, they only present one issue before the court. Now, that surprises me because I think they had more than one issue, but this is the issue they presented. If you're not familiar with appellate work, it is way different than pleadings or filings in a court of initial impression. Schmutz! That's it! It's schmutz! Thank you, Adam. Thank you. I had schmutz on my glasses. You can tell I haven't been in South Florida in such a long time. It's been such a while, but when you live in South Florida, Yiddish is part of your vocabulary, and there aren't equivalent English words. Schmutz is so perfect, just like tchotchkes. When I came out here and people didn't know what I was talking about when I said tchotchkes, I was like, what? How do you not know schmutz? How do you not know tchotchkes? Thank you. Thank you very much. Oh boy. It was such culture living in South Florida. I knew so much Spanglish, so much Yiddish. It was wonderful. Anyway, now that we got past the schmutz, they go on about how these appeared on the website for 4 months, so on, so forth, whatever. And, we were going to issues presented. Sorry, I went off on a little bit of a schmutz tangent. So in appellate court, you do recite the facts for the convenience of the court, but you also, at the very beginning, usually there is a table of cases cited. This is weird. I don't know what the Colorado Supreme Court local rules are, but this isn't presented or formatted like appellate stuff is usually very heavily formatted with an index that says what page numbers that statutes are cited on, so on and so forth. Maybe Colorado Supreme Court doesn't require that. I'm going to have to go look at my own Supreme Court case. I didn't write it, but I was a Supreme Court plaintiff in a case that allowed you to take your ballot selfies in Colorado. I did that in 2016. Thank you very much. You're welcome very much. It wasn't just me. It was a multi-partisan group of plaintiffs. Okay, so it says, the issue presented, whether the secretary committed a wrongful act and/or otherwise breached her duty to adequately supervise and conduct Colorado's 2024 general election and to secure the purity of Colorado's 2024 general election by publishing the BIOS passwords of 255 acting voting system components on the Secretary of State's website for over 4 months before said election. So now they really are narrowing it down to a failure to supervise. They are not claiming that she did it herself. They are claiming that she didn't adequately supervise her staff. Okay. And I can get on board with that. And as I said before, we know that foreign countries are constantly scanning our government websites for sensitive information. Why we aren't self-spying on ourselves, if that's the right word, if we don't have the same kind of software that they do and are not scanning our own systems for vulnerabilities, that just seems a little wackadoodle. All right. So, introduction. They say the Supreme Court has jurisdiction. They do. And they're asking for a reversal, at least in part, of the district court's decision regarding the failure of respondent Jenna Griswold in her official capacity as Colorado Secretary of State. I want to get this right up front. She did fail. I don't think she failed in the way they're saying or to the extent she is saying. She, as I can't pronounce her name, but it ends in 1800, is just incompetent. She's just no good. I don't think it was malicious. I think it was just utter incompetence. Should Jenna Griswold resign? Yes. Should Jenna Griswold be in prison? This is where libertarians get really mad at me. It's funny how bloodthirsty libertarians become. No, this is not the same in any measure as the Tina Peters case. Now, do I think Tina Peters belongs in jail? No. I think Tina Peters, I've got like hair stuck all over the place. That's where I'm like pushing. I think Tina Peters is a hero. She does not deserve to be in prison. But to say the two cases are the same, you're either ignorant, which is very curable, you're lying, which makes you a bad person. I guess it's just either those two. Or you just have an agenda and don't care whether you're ignorant or lying. Tina Peters very purposefully, as a whistleblower and to prove a point, breached voting systems. Now, I think she's a hero for doing that. She does not deserve jail time. But everything she did was deliberate and knowing. That is not what Jenna Griswold did. Jenna Griswold is just a terribly incompetent Secretary of State. 2332 says, is lying curable? It depends. It depends, because this is going to come up later, but I took this voluntary lie detector test over something. And one of the questions on the lie detector test was, have you ever, oh, no wonder it seems so dim in here. I didn't put my two front lights on, but it seems okay. I'm not going to get up and put those two front. I might like the lighting better in here without those two front lights. One of the questions on the lie detector test was, have you ever lied to your family in order to protect yourself, like you did something wrong or whatever? And my answer was yes, of course. So everyone has lied. You're a liar if you say you never lied. The only human, and wasn't even only human on this earth, who has never lied was Jesus Christ. If you're not Jesus, and I don't believe you are, you have lied. So, yeah, I guess it's curable to a point. But when you're starting to lie for political agendas or lie over things you should know better about, and you're an adult, you're not a teenager who's sneaking out of the house to get a little kissy time with your boyfriend, I don't know. It depends. Lying maybe is curable. Ignorance definitely is curable if the person wants it to be cured. Okay. So, repeating the facts we already went to. Okay, jurisdiction. They say there's no other pending cases. And this is where I think the chutzpah, to use another Yiddish word, of the Libertarian Party of Colorado comes out. There's a reason there are no other pending cases. Now, I know the big horse energy gal will state that the reason there were no other pending cases is because they were the only ones with the guts to do it. Are you serious? Even though the Republican Party in Colorado is not very powerful, we are a thoroughly blue state, they still take in millions of dollars a year. Whereas right now, at least as of the last reporting, the LPCO had in its bank account less than $10,000. So the power dynamic differential is huge, as an incoming president would say. The reason why they didn't file a lawsuit is because they didn't think they would win. Okay? Yes, narcissistic. That was an incredibly autistic loss. And you know it's going to be bothering me the whole time now, going, I wonder if I'd look better if that lighting was on. But I actually kind of like it right now. Anyway, so that's the reason. It's not that the LPCO has so much more balls. It's not because they're that much smarter. The Republican Party didn't file a lawsuit for a reason. And I think we learned the reason by the swift dismissal of the district court case. So there are no other cases. So, and then it gives the statement of the case. And we know about that. We did that in another show. I'm going to see, though, if they added anything new here. And again, sorry because of my vision that it's taking me a little bit longer to scan through these pages than it normally would, but I don't think there's anything new for a bit. Okay. Now they're starting to recap what happened at the district court level. And it said the district court, which in Colorado, this gets so confusing. So, I'm from Florida originally. In Florida, if you're not in small claims, if you're over, I think the jurisdictional amount was $15,000 at the time I used to live there, you would be in what was called circuit civil court. That was your first layer court. And then district court was your next level of appeal. In Colorado, district court is your first. Why can't we have a standard naming system? The lower court in D.C. is called the Superior Court. Wouldn't you think the Superior Court wouldn't be a lower court? It is so confusing when you try to do multi-jurisdictional practice. That's why I like federal court. I love doing federal work because there's one filing system, PACER. Any of paralegals out there are saying, amen, sister, preach it. It's so inconsistent. Now, I don't believe in centralization and all of that, but you know how just naturally, you didn't need laws for certain standards to develop. I don't know why that didn't happen with the court systems, because it is so confusing, and I've been doing this for 35 years. I cannot imagine how confusing it is to a lay person. That's why we have a two-tiered justice system in this country, because your average person wouldn't know the slightest thing to do on how to start a lawsuit. Ask your average everyday person, your plumber. Ask your plumber what a civil cover sheet is. They won't know because it is so hard. I had trouble filing my own pro se case, and I have all this experience, but the experience isn't in election law. It was an insurance defense. I feel so bad for people whose rights have really been violated, but the court systems are completely opaque to them. They really are. Okay, sorry, that was a bit of a rant. I just don't like the justice system in this country. And it wouldn't be that way under anarchy, by the way. Okay. It says on the day of the election, the ruling was issued. And the court adopted that the respondents' position, meaning the Secretary of State's position, that the petitioners had to they failed to exhaust their administrative remedies. That's a whole other thing. Like, what court do you file it in? There's administrative courts. It turns out they were supposed to file this in administrative court first. I didn't even know that. Like, that would have been news to me. So that was one of the main reasons it was dismissed, which was something I didn't anticipate because I didn't know. Okay. It said the district court noted that the petitioner's burden to establish that an officer has committed a breach, neglect of duty, or wrongful act, and after notice, including the, it's my eyeballs again, including the opportunity to be heard. If the court finds good cause, the trial court shall issue an order requiring substantial compliance with the Colorado revised statutes. Now, I think the reason that the court did not issue such an order is that it determined that that this 2-password system that is allegedly required, and her immediately changing the leaked BIOS passwords, which was only one part of 2, was substantial compliance. But they say, however, the district court focused on the petitioner's position that the secretary's conduct violated, and I'm not going to cite the statute. And they did. And I told you in the other show, I told you that they shouldn't have focused on this, because let me read it. Any person who knowingly publishes or causes to be published passwords or other confidential information relating to a voting system shall immediately blah, 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 and be guilty of a felony and all of that. And that is where Tina Peters got in trouble. The district court determined that the record before the court lacks any evidence that the conduct related to the BIOS passwords on the Secretary of State's website was done knowingly. And they are right. There was zero evidence of intent. In this statute, to convict someone of a Class 5 felony and have their authorizations revoked, they had to have knowingly done that. You might not like that is part of the statute, but it is part of the statute. Mens rea usually is a portion of a crime. This is a criminal statute of a Class 5 felony. Now, with Tina Peters, she obviously had the mens rea, but I think there was mitigating factors, namely that of her being a whistleblower, that, again, canceled that out. That's a whole different thing. Okay. And we went over that in another show, because I'm trying not to repeat a bunch of stuff. I'm just trying to give you a little tease, a little taster of what they did. So they go on and repeat the ruling. Fine. And then they say, the Supreme Court must rule on this matter of great public importance. And they give some case law as to why they must do that. I don't find it particularly convincing. But here's what's very, very interesting. In 1800, I'm going to answer I want to put this on the screen, because this is something that I think you've been misinformed about. He said that I would argue if she hid the spreadsheet tab with an understanding that simply unhiding the tab will expose it. And there's another comment. He says, then proceeded to post the spreadsheet online. I'm going to correct you here. She didn't hide that spreadsheet tab. She personally had nothing to do with the spreadsheet at all. This was done by an employee that no longer works with the Secretary of State's office for reasons completely unrelated to this spreadsheet. She didn't know about this spreadsheet until I think it was October 24th. So 1, she didn't post it online, and 2, she didn't hide the tab. Okay, it says, the secretary spent the first 5 days after having been made aware of the security breach, consulting with CISA and vendors of Colorado's electronic voting system. She chose to spend those 5 days painstakingly scouring the spreadsheet to determine which of the county's components were affected, instead of informing the 34 affected counties and ordering them to discontinue processing ballots until cyber teams could take corrective action on the county's election system. This was a judgment call on her part. Do I agree with her judgment call? I don't know all the facts. That's the judgment call she made. I think part of the reason she made that judgment call is that the one BIOS password alone was not enough to get into any voting system. 1800 asks who uploaded it. It might say it in here. I don't know. Right now, I don't know. All I know is that it's an employee that no longer works there, hasn't worked there for at least a few months, and left. And I don't know whether he left or was fired, but is no longer employed there. Let's put it that way, for reasons unrelated to this spreadsheet. And then, so they're criticizing her 5 days, the way she chose to spend the 5 days. Okay, they're arguing statutes. And said they can't get a transcript of the hearing because it was only a couple days ago. Totally get that. I kind of totally get that. But as many of you know, I sued the Libertarian Party of Colorado over their breach of bylaws. And there was transcript that this same attorney wanted, and he was able to get it overnight. Usually, if you're willing to pay enough, you could get a court reporter to transcribe something in 48 hours. So I don't know. I find it kind of strange they couldn't get a transcript in 3 days, but maybe the court reporter was sick. There could have been any number of reasons. Okay. Basically, just arguing about the statute, doesn't even try to overcome the knowingly part. Just tries to go, the district court concentrated on that wrongly. Now, I have sympathy for the fact of the district court concentrating on something wrongly. Originally, in my case, they kept concentrating on the fact that this was a political party and we don't want to get involved in political disputes. And I had to say over and over again is that no, this was not. This was about an incorporated nonprofit that just happened to do political work. That this wasn't about a political controversy. It was about a contract. It was about the bylaws. And it took a long time. The second day, I think the district court finally understood where I was coming from, that this was a breach of contract issue. So I have sympathy with them thinking that the district court focused too much on knowingly. Now, I don't think they did, but I have sympathy for the feeling that they did. In which case, they should have spilled a lot of digital ink talking about how it was inappropriate to focus solely on that word, but they didn't. They only mentioned it in passing. Okay. Now, they have as an exhibit the original petition, which we went over on the show. But what we have here that I didn't have before, sorry, Nita, some soda. We did not get to read this. At least I don't think so. I don't remember. And it is the Secretary of State and the district attorney's response. Now, this is kind of stale because they won, but I'm interested as to what their argument was. We're just going to go through it briefly because it actually doesn't matter. The court already ruled. She calls it an unfortunate mistake. Mistakes happened. An unfortunate mistake. Mistakes were made. Okay. But then goes to talk about the multiple levels of security, which we did go over. It's the factual background. I want to see if there's the name of the employees on here. That's what I'm scanning for. He goes, their request that this court grant them extraordinary and unprecedented relief, which the LPCO granted. It was extraordinarily relief that would upend the November 5th general election is based on supposition alone and therefore should be flatly rejected. I actually agree with that statement. It was based upon supposition. Now, there should be a thorough investigation. From what I understand, the district attorney's office, I drank that Mountain Dew too fast, is investigating it, but oddly enough, has said that Jenna Griswold's not the subject of the investigation. Again, that goes towards the knowingly thing. I don't think anyone believes that she knowingly did anything. I think everyone just thinks she's kind of dumb. Okay. Let's see here. They began investigating. Blah, 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 blah. The obsolete passwords have been updated. It says one of our counties always hand counts, so they don't matter to this whole issue. Yeah, this is just all we went over this without even reading it. I think that the court kind of went over this in their order. Okay, petitioners have not shown they are entitled to their stated relief. Okay. Claims the secretary was in strict compliance with this administrative code. Don't know if that's true or not, but the court ruled in their favor, so doesn't matter what I think. So, they state, as noted above, the current extent of non-compliance is 0. I don't buy that, but I also don't buy, oh my God, push the panic button. I do think this is definitely a warning shot to have a more competent person as Secretary of State. And Jenna Griswold needs to resign. She won't, but she should. So it says the petition here does not contain any verified facts for which Ms. Goodman and Mr. Wiley have sufficient personal knowledge and therefore failed to establish that either of the respondents had actual knowledge that the BIOS passwords had been posted to the department's website in violation of. So they were relying upon the testimony of somebody else. And then it said they also failed to allege that any employee, so not just Jenna, any employee knowingly did so. Here's something interesting. Or even constructively did so. What did they accidentally post it? I don't know. That kind of is. That's wonky. That's wonky. Somebody posted it. That's for sure. Somebody posted it. Okay. All right. Here's the order. We already went over that. I'm just trying to give you all new stuff to let you know where we're at. Hold on a second. Here's something that you might want to find interesting. And anyone who wants it, just write me and I'll send it to you because I obviously paid for all of this stuff already. Here is the person that discovered, the affidavit of the person who discovered the passwords. It's a Sean A. Smith. And he gives the address of where he found this. And I'm wondering if anyone goes, and if I had better vision, I would do this myself right now. But write me if y'all want this, or I can say it out loud if you want to write it down. I'm wondering if we go back to the Wayback Machine, if we can see these spreadsheets ourselves. So I'm going to read it. Obviously, it's https:// www.coloradosos.gov/ pubs, pubs, / elections, / voting systems, / V as in victory, S as in Sam, homepage 1, which is the number 1, .html. So I would love for someone to go to the Wayback Machine to see if you could still get these voting spreadsheets. And if you want these affidavits from Sean Smith, for some reason it's filed twice. I don't know why, but it's filed twice. But I think it's interesting that I wonder if you could download that spreadsheet and look at, I probably shouldn't be saying this because I don't want them scrubbing shit. I wonder if you can go to that website, Wayback Machine, and download it and then look at the properties of the Excel sheet. If you go under, I have a Mac, but under Windows, I'm sure it's similar. You go under File, then Properties. Sometimes it says the author and like the machine it was uploaded from and the date it was created. It can give you all kinds of interesting information under Properties. This is the temporary rule that was adopted. We already went over all of this. Somebody do that. I really want to know. Okay, so here's the juicy part. This is what all this was getting to. Order of the court, November 12th. Yeah, 1800. Sorry, I can't pronounce the first part of your name. Let me put this up on the screen. Yeah, the right info will give you the edit date and even the dynamic address of the computer. Yeah, a lot of people. I know that because some of you don't know my background. Let me give you a little bit about my background. I did say it was an insurance defense, but a lot of people think personal injury. When you say insurance defense, I did property insurance defense. And for the first 15 years of my career, I worked nearly exclusively on fraud cases. So which made me uniquely qualified when it came to digging into some of the history of the LP and forensic document history and things like that, because that's what I used to do professionally. So anyway, yeah. I used to know what Whois was before people even understood what websites were. I jacked up the phone system in the law office I used to work with. I'm really dating myself. We had a law library. There wasn't online. When I started working, we barely had our case files online, but all the stuff you type, but all the files were paper. We had no online. I jacked the phone jack in order to get onto AOL through a phone modem. Okay, I kind of love that sound. So I go way back. We had a law librarian. We had a law library. We actually had physical copies of Shepard's. Now, I know this doesn't mean anything to any of you guys who aren't in law, but I have literally physically Shepardized cases, okay? I know how to Shepardize. Used to be a bookkeeper at Service Merchandise before that. Now I'm really dating myself because Service Merchandise has been gone a long time. And when I did bookkeeping at Service Merchandise, it was all double entry on paper. So, which you then went and input into the computer, which double checked your calculations. But when the computers would go down, all these new bookkeepers were absolutely lost on how to do the accounting for the day. But I knew how to do it all on paper. So they'd all be calling me because I was trained on double entry bookkeeping on paper. And they didn't realize if it was off a penny on one side, it usually means there was a 2-penny mistake on the other side because it doubles itself. Anyone working in bookkeeping knows exactly what I'm talking about. But I have reconciled millions and millions and millions of dollars of accounts at Service Merchandise. We had that big ass vault, that you'd have to open. I could tell you some jokes about Service Merchandise. I did hand inventories at Service Merchandise. I could tell you some Service Merchandise stories. So, this is what I wanted to read to you before I was going back into the past like an old lady. Upon consideration of the petition for review pursuant to CRS, blah, 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 it is ordered that the court declines jurisdiction to review the petition. So basically, the Supreme Court said to LPCO, LOL, okay. Okay, thanks, bye. That's basically what happened. I heard is the wrong word. Bird is the word. I read on Twitter, can we appeal this now to the Supreme Court? I don't think so. I'm not positive on this. And I kind of skipped past it. But in the district court, it says there's an automatic right of appeal to the Supreme Court who can decline to hear it. But if they decline to hear it, that's the end of the road. Now, I don't know if a state can say that, though, in a statute. That's not my area, but it's my understanding that it's done. You can't appeal to the Supreme Court. If the Colorado Supreme Court took it up, then perhaps the U.S. Supreme Court, if it involved a constitutional question. or a conflict between states. See, people forget that the U.S. Supreme Court has a very limited jurisdiction. You can't be in an argument with your neighbor over a tree overhanging the fence and keep appealing and finally get to the Supreme Court. The Supreme Court has a very, very limited jurisdiction, and constitutional issues are one of them, and disputes between states are one of them. And I don't think this meets any of the jurisdictional requirements. And also certain federal statutes, the Supreme Court has jurisdiction over, such as the Lanham Act, which I ended up becoming very familiar with in a trademark lawsuit that I was assisting in. They apparently amended their petition because they did a motion to amend petition for review by interlineation, and it was granted. But I don't know. They didn't give a redlined version of what the changes were. So I'm just flipping through to see if it's obvious to me. Oh, they talk about the Smith affidavit in here. And I don't think they did in the other one. But maybe they did. Oh, and they said what the columns on that spreadsheet were. And I don't think that was in the original affidavit. I could be wrong. I wish they gave a redline version. In the Superior Court of D.C., when you amend a petition, you have to attach as an example a redlined version so that the court can quickly see what you changed. And I really like that. That's not required in Colorado District Court either. But I really, really like that. So it seems that they just added some information from the Sean Smith affidavit. So that's where we're at. Where we're at is that lawsuit is over. Unless the Secretary of State, through some kind of statutory scheme, is not allowed to get fees, they are probably going to get fees from the LPCO, but maybe not. Don't know much about that. I guess we'll find that out. And it's not going anywhere from here, except that the DA has opened an investigation. So to answer the question that was asked earlier, what is the name of the employee that did this? I don't know. I want to know, though. I don't necessarily want to say so on my show. I'm not looking for anyone to be harassed. What I'm more interested in is the circumstances of his or her separation from the Secretary of State. Did they get a better job? Were they fired for incompetence in some other area, for making a mistake in some other area? I'd like to know the circumstances under which this spreadsheet was uploaded. I'd like to know, those things are much more important to me than a name, because I'm not looking to ruin anybody's life. If I find out the name, I'm not saying it on my show. I'm just not into that sort of thing. People get death threats. People get doxxed. It's not cool. It's just super not cool. Okay, that is it on that case. If there's any further news on it, I will certainly report it to you. So now, if that's all you wanted to hear about, you can skedaddle safely. But if you wanted to hear a little bit about the Libertarian Party tea. Sorry, I do have a bit of the sniffles. Now's the time to stay. And I also just found out I marked out wrong. I didn't just find out. I found out earlier today, but I just found out today that I marked my calendar wrong. And tomorrow I'm supposed to be giving a presentation before a bunch of paralegals on the intersection of parliamentarian services and expertise and the paralegal profession. Fun. I've got to create slides. I'm probably going to be up all night. I put it down as December 20th. I'm so glad that Emily wrote me earlier today. Now, I don't really need slides. I could talk for an hour on it, but I like to be prepared. I like to be professionally prepared. Plus, I might get some work out of it, and there's nothing wrong with that, is there? I'm a capitalist. There's nothing wrong with that. So the Libertarian Party tea. As some of you, may have heard, there was a trial on November 9th. And of course, they found me, burn the witch, guilty. And I have had a limited period of time to write an appellate appeal, which I did, which is why my eyes filled up with blood from the stress of having to do all of that after having severe COVID and then the flu. Hopefully that kind of stress level is not going to happen again. I would hope not. I hope I'm on the mend from that. That's why there were no shows last week. I was writing my appeal from morning till night. The LNC has 7 days to write their response to my appeal. I highly suggest everyone read my appeal. You can find it on LPedia, or you can email me for the link. You could also find the link to it on Third Party Watch. I think it's thirdpartywatch.com. Right now it's the top article, but you can find it easy enough. I know 57 pages is a lot of pages. It could have been 107. There were so many errors made. But one of the exhibits is a lie detector test I took because I was so incensed at a lie that was told about me. I want you to ask yourself, how motivated does a person have to be and angry, considering my broke ass, to go and pay $500? It was $475, but let's just round it up to $500 to voluntarily submit to a lie detector test because no one calls me a fraud. I don't care who you are. You do not. So I'd like you to go and read that report and go and read the lie detector test because I got a 99% truthfulness rating. The polygrapher told me nobody gets 100. I got the highest rating there possibly can be because I am telling the truth. Just think about what it takes to drive a person to do that in order to clear their own name. And I challenged the person who lied about me to go take a similar test without response. So you judge for yourself as to what weight you should hold to that. But just know that that's driving somebody to the edge right there, because you do not call me a fraud. I can be wrong about things. I can blab. I can be rude sometimes. I could be a catty little bitch sometimes. But one thing I am not is a fraud and a liar. So I went and took a voluntary lie detector test. And the lie that was told about me was so stupid. That's when you know you're dealing with a chronic liar. Because on big things in life that could really ruin your life, I think nearly all of us are capable of lying. You don't know until you're in that situation. But when you lie over dumb stuff, that's habitual. That's a problem. That's a problem you need to address. So thank you, Adam, and thank you, Narcissistic. If you go to that article that Adam linked, which I will put up on the screen here because people watching this later will not be able to see that, you will see that there is linked a package of exhibits. My lie detector results, along with the qualifications of the polygrapher, are part of those exhibits. I can't remember what exhibit number it is. You might notice that exhibit 14 is missing. That's because when I was numbering them, because I had such limited time to file this appeal, I skipped 14 by accident. There isn't a 14. It's not missing. There just isn't a 14. And 12 had to be sent separately because it's a parliamentary opinion that's password protected, so it wouldn't let me in Adobe combine it into one big file because I don't have the password. So I had to send it separately. So I encourage you to go read that. And I also encourage you, when the LNC files their response, to go read that as well. Dr. Moulton filed an excellent amici. I do not know if that's up yet. Any of you, I would welcome your amici. But what I'm going to ask you not to do, that people were asked to do last time, is completely inappropriate. Do not spam the JC with emails. If you have something significant to add, even if it's just a couple sentences, give them the respect of their position and put it in a formal. And formal just means you say the title of the case and attach it to an email and send it to them. Don't copy paste something because some caucus told you to do so. That is very, very disrespectful to the Judicial Committee. But if you feel you have something to say, one way or another, for me, against me, neutral, then please do file an amicus brief. I would highly encourage it. If you have questions on how to do that or who you need to send it to, please feel free to reach out. Now, when it comes to the substance of the appeal and all of that, I'm not going to be talking about that on my show. If you want the details, you can read my petition. It's all in there. Well, there could have been more, but the substance, the major substance of it is in there. If you really want to know, you'll read it. I'm not going to be talking about it on my show. I think that's disrespectful to the JC. It politicizes them, and I'm not going to do that. I will let you know when there is a hearing set. A hearing has to be set between 20 and 40 days from the receipt of my appeal. They received my appeal on Saturday, so I think that means that the hearing has to be between December 6th and December 26th, and then they have 30 days to make a decision after that. So I don't think they'll take 30 days. Last one did, but I don't know. Now, Mr. Phillies has his own appeal, which is related to mine, but not the same thing. It's done as a member of appeal, has a different standard of proof. It's different. There is a hearing on that appeal, and you can write me. I can get you the Zoom info. It should be posted on the LP website, but rules, mules. But I can get it to you if you'd like it. I'm not attending that because the issues do relate to my appeal, and I don't want mine to be influenced, good, bad, otherwise, prejudice, good, bad, otherwise, by a separate appeal by members. So I would encourage you to attend. I will probably watch the recording later, but I will not be there that Saturday. Wayne and I will probably be out trying to snowshoe again, which we tried to do last Saturday, but the place we went to was too packed down. All right, that is all. I am going to urge once again, we can call it e-begging if you like. Please become a patron if you can. I really, really, really appreciate it. And also, I do have YouTube members only, and you do get benefits. You do, in fact, get benefits. And last but not least, super chats always matter, but I've also been getting some super thanks, which are people who watch the show afterwards. And I guess there's a little button that says you can send a tip to your hostess. I would really appreciate it. Okay, everyone, I hope you have an awesome night. I don't think there will be a show tomorrow because we have plans with friends. But maybe there will be one late. But I wanted to get you this color. Look at me bouncing my basement floor. I have what's called a floating basement. It's not cement. So I hope you have an awesome night and that I'll be back on a regular schedule. All right. Bye-bye. Love you.
You gotta take what you're given, that's how we live it. Don't be mad at the system, it's simply how we've existed. I hear a lot of people talking like they politicians or choose to be an accountant because it's safe in the business, not because they want to